I'm sorry, I can't release this today.
It's my own money, but why not?
If you're 65 or older, walk into your bank this week and ask to pull cash for something ordinary. Paying a contractor, helping a grandchild, closing out an account. And your bank can say no, not delay it a day. Say no, and keep saying no for up to 15 business days. Susan found that out on a Tuesday afternoon. She'd sold her car that morning, deposited the check, and asked for cash to pay the contractor waiting in her driveway. The teller typed for a minute, said, "1 moment," and came back with a branch manager instead of Susan's money. Susan hadn't broken any rule. The sale was real. The contractor was real. The amount matched exactly what she'd told the teller she needed. None of that mattered. Under a law that now covers roughly half the country, a bank employee only needs a hunch, not proof, to lock a withdrawal in place. That hold can run 15 business days. In some states, 30. In at least one, it can stretch to 90, 180 if an investigation is still open when the clock runs out. Quick note, I'm not a lawyer or your financial advisor. This is the briefing that helps you ask your bank the right questions. Here's the part most people get wrong about what just happened to Susan. The bank didn't need to prove anything. The legal standard is called reasonable belief, not evidence, not a police report, not even a pattern built up over months. One employee, one transaction, one gut read that something looks off for that customer, and the hold is legal on the spot. Think about what that actually covers, because the list is wider than most people assume. A large cash withdrawal you've never made before, a wire to someone you've never sent money to, paying a contractor in cash because that's how contractors like to be paid. A gift to a grandchild that's bigger than your usual transactions. None of those are crimes. Every one of them can trigger a hold, because unusual for this customer is measured against your own history, not against any national threshold. There's no dollar figure written into the law that says this amount is safe, this amount isn't. It's discretion, teller by teller, branch by branch. And banks use that discretion more than you'd think. In states with these laws on the books, surveyed banks report delaying transactions anywhere from once a month to several times a week. Not rare edge case events, but a routine part of how branches now operate. The law protects the bank from making that call, right or wrong. If the teller's read turns out to be completely mistaken, no fraud, no exploitation, nothing, the bank still isn't liable for freezing your money. That's not a loophole slipping through the cracks. It's written into the statute on purpose, specifically so employees don't hesitate out of fear of getting sued for acting. So the uncomfortable version of this rule is, you don't have to be a victim of anything for it to apply to you. You just have to look for one moment like you might be. And the bank has every legal incentive to guess wrong in the cautious direction. If you've been banking for more than a decade, you already know a rule that sounds like it belongs in this conversation. The bank has to report anything over $10,000. That's true. And it has nothing to do with what happened to Susan. The $10,000 rule is called a currency transaction report. It's decades old. It applies to every customer of every age, and it exists to catch money laundering, not to protect seniors from exploitation. When you trigger it, the bank still hands you your cash. They just also file paperwork with the federal government afterward. Your money moves. You walk out with it the same day. There's a second federal rule people sometimes confuse with this one too. A suspicious activity report, which banks can file on transactions as low as $5,000 if they can point to a specific concern, or $25,000 even without one. Same story. It's paperwork filed behind the scenes. It doesn't stop your withdrawal, and by law, the bank isn't even allowed to tell you it happened. What held Susan's withdrawal is a completely different law, aimed at a completely different problem, and it doesn't care what the dollar amount is. It's not a reporting rule. It's a permission slip for the bank to say no in the moment, before any money moves at all. So if you've spent years quietly reassuring yourself that you're fine as long as you stay under $10,000, that reassurance was never actually protecting you from this. These are 3 separate rules that all happen to involve a bank, a withdrawal, and a form. Past that, they don't overlap, which raises the obvious question. If it's not the amount that starts this clock, what is it? Here's what makes this harder to plan around than most rules in this niche. There's no single national law. There's a state-by-state patchwork, and whether you're covered or how badly depends entirely on your zip code. Roughly half the country has one of these hold laws on the books right now. The other half doesn't. California is the clearest example. Lawmakers passed a bill to create one in 2024, and the governor vetoed it. If you bank in California, this specific mechanism largely doesn't apply to you, at least not yet. Florida sits somewhere in the middle. Its law, in effect since the start of 2025, lets a bank hold a disbursement anywhere from 15 to 45 days, depending on how the investigation goes. Already 3 times longer on the high end than the floor most states set. Georgia sits at the far end. A new law there takes effect this month, and it's one of the stronger versions in the country. A bank can hold a disbursement for 15 business days, extend it another 15, and can take up to 90 days total to reach a decision. If an agency investigation is still open when that 90 days runs out, the window stretches to 180. Idaho passed its own version the same year, a law nicknamed Report and Hold. States aren't slowing down on this. They're adding these laws faster than most people can track which ones apply to them. And it's not just lawmakers pushing it. Surveyed banks in states that still don't have a hold law overwhelmingly said they wish they did, nearly 9 in 10 of them. Which tells you where this is headed. More states, not fewer. And the patchwork you're dealing with today will likely look different and stricter within a couple of years. Same country, same age group, completely different level of protection or exposure, depending on which state you happen to bank in this year. So tell me in the comments, what state are you in? I want to know how many of you are watching this with a law already active on your account right now versus how many of you have none at all. There's one document that cuts through this entire patchwork, works the same way regardless of your zip code or which version of the law your state has. And most people watching this have never heard of it. Susan's hold didn't last 15 days. It lasted 6. The bank released her cash once the branch manager reached her son, confirmed the car sale was real, and closed the file. 6 days felt long enough when the contractor was standing in her driveway, asking when he'd get paid. 6 days is actually the fast outcome. 15 business days is the floor most states set for an initial hold, not the ceiling. Almost 3 calendar weeks, once you count the weekends folded inside those 15 business days. And initial is the word to sit with, because most of these laws are written to extend. Some states allow a second 15-day period once the first one runs out, 30 business days total, 6 calendar weeks before the bank has to make a final call. Georgia's new law goes further still. A bank there can take up to 90 days to reach a decision. If a state agency has opened an investigation and it's still active when day 90 arrives, the law allows the hold to run all the way to 180 days. Sit with what 180 days actually means for a retired household living on fixed income. That's 6 mortgage payments, 6 rounds of property tax escrow, utility bills, prescription refills, a car payment, all due on schedule, while the money to cover them sits behind a lock you can't open on your own. For a hunch you may never even get details about, because banks aren't required to explain their reasoning to you while the hold is active. Run the math on what that actually costs downstream. Most mortgage servicers charge a late fee once a payment passes 15 days overdue. A new charge every single cycle the hold stays open. Miss 2 consecutive payments and many loans are contractually in default, which the servicer can report to the credit bureaus regardless of why the payment never arrived. The bank holding your cash isn't the bank holding your mortgage, and the mortgage servicer's clock doesn't pause because a different institution decided your withdrawal looked unusual that week. And there's no fast legal remedy while you wait. The same law that lets a bank freeze your withdrawal without proof also grants that bank immunity from being sued over the decision, as long as it acted in good faith. Before laws like this existed, a bank that froze a legitimate transaction risked exactly that kind of lawsuit, for wrongful dishonor. In the states that have adopted this framework, that risk is gone for the bank, which means the legal system, working exactly as written, gives you no faster way out once the hold starts. Your only real lever is the one that works before it happens, not after. And this isn't a rare worst-case footnote. Banks that use these laws report doing it routinely, some delaying transactions weekly, some daily, which means the 90 and 180-day version isn't reserved for dramatic fraud cases. It's built into the same statute that covers an ordinary contractor payment like Susan's. The difference between her 6-day resolution and someone else's 6-month one often comes down to nothing more than how fast the bank can reach a person who can vouch for the transaction, which is the piece most people watching this don't have in place yet. There is a single form that changes everything about what just happened to Susan and to the households sitting in that 90 to 180-day version of this story. It's called a trusted contact person. Here's what it actually is: a name and phone number you give your bank in advance, a son, a daughter, an attorney, anyone you trust, that the bank is authorized to call the moment a transaction looks unusual. Not a joint account holder, not someone with access to your money, just a person the bank can phone to ask one question. Does this look right to you? Watch what that does to Susan's timeline. Without a trusted contact on file, the branch manager had to independently verify her story, track down her son, confirm the car sale, document the file, close it out. 6 days. With a trusted contact already listed, that same call happens in the first hour. The bank reaches the person, gets a "yes, that's legitimate," and releases the hold the same day. 15 business days, 30, 90, 180. All of it collapses into a single phone call because the bank already has someone it can reach. And this isn't a workaround or a loophole. It's built directly into these same laws. It's the release valve the statute itself provides, sitting right next to the hold authority. Most banks will add one to your account for free in a single visit or a 5-minute phone call. No fee, no paperwork beyond a name and a number. The reason most people watching this have never heard of it isn't that it's hidden. It's that banks aren't required to bring it up unless you ask. It sits in the fine print of account paperwork most people sign without reading, waiting for someone to request it by name. So if you take one thing from this video, take this. Call your bank this week, not someday, this week, and ask specifically for a trusted contact person on your account, not a joint owner, not a power of attorney. Those are different tools for different problems. This is the one that's free, takes minutes, and is the difference between a 6-day inconvenience and a 6-month one. 3 things to do with this, in order. First, this week. Call your bank and ask for a trusted contact person on file. Do it before a teller is standing between you and your cash, not after. A hold placed on a Tuesday doesn't wait for you to set this up on Wednesday. Second, ask your bank directly whether your state has one of these hold laws and get the real numbers. The initial hold length, whether it extends, what the maximum runs. Don't assume Georgia's 90 to 180-day version applies to you. Don't assume California's lack of a hold law protects you from every other kind of delay a bank can impose. For comparison, Florida allows 15 to 45 days. Georgia allows up to 180. California has neither law on the books. 3 states, 3 completely different realities, and yours is worth knowing before you need it. Third, if you already know a transaction is coming that might look unusual for you, selling a car and pulling the cash the same day, sending a large gift for a wedding, paying a contractor in cash, call ahead and tell your bank what's coming and why. Reasonable belief is measured against what looks normal for you. A bank that already knows what's coming has nothing left to flag. The hold law and the trusted contact provision come from the same statute, written by the same legislators. One half stops a stranger from emptying your account. The other stops the system from mistaking you for that stranger. Most people only ever hear about the first half. If this is the first time you've heard about the second half, that's what this channel is for. Subscribe if you want the next one before it catches you off guard instead of after. Tell me in the comments which of the 3 you're doing first, not someday, this week.